said. You know what doesn't make sense? Is tickling the thighs of your niece and going up under the shirt of your niece and tickling her there. To me, that doesn't make sense. We move right into Mr. Schulte, very good attorney, very experienced attorney. Where he's going towards the end is he's setting this up as a he said, she said. We talked about this in jury selection. He said, she said. It comes down to something that she said that happened almost 10 years ago versus what he said. Even if that was the case, which it's not, the instructions ask you to gauge credibility. The instructions say that conflict in testimony doesn't necessarily mean that you can't get beyond a reasonable doubt. It's exactly what it says. If that was the case, anytime anybody was a victim of a crime to which there were no eyewitnesses, they'd never be held accountable. My Bart and Bob example. Love it or hate it, Bart and Bob. Bart shoots Bob. Bob's dead. Witness sees Bart shoot Bob. And in my example of voir dire, we had a he said, she said. And I asked one of the prospective jurors, I can't recall who it was, well, what else would you want to know? What other evidence in that scenario would you want to help prove up the case? What information you need to help make a decision? And I got some, I don't know, but I put forth, well, what if Bart was interviewed by law enforcement and put himself at the scene of the crime? Would that help? Sure. What if Bart was interviewed by law enforcement and told law enforcement, yeah, my fingerprints are on the gun, but I didn't do it. And that's what we have in this scenario. Defendant, during his interview, puts himself at the scene of the crime. He puts himself on the victim's vagina. But it was an accident, or she misunderstood. Or when I was turned a certain way, I was, cuddling with her. He puts himself at the scene of the crime. This is not a he said, she said. One of the additional instructions, it's not additional, it's one of the instructions, talks about credibility. This has destroyed families. 10 years later, what is Kayla Smith's motive to come forward 10 years later, knowing she's going to destroy the relationship she has with her family? The very reason she didn't come forward in the first place. No motive. Absolutely none. In fact, there's more incentive to keep her mouth shut, but she didn't. Defense counsel takes certain liberties with evidence that arguably is or is not into evidence as far as defendant being read his Miranda rights. If defendant was read his Miranda rights and was told that he could not leave, we wouldn't be here. He would be under arrest. Anything he would have said after that, unmissable. That's not the case. And the reason why defense counsel wants to hone in on the browbeating that Detective Barrett, the power of the state coming to bear on defendant, he wants to focus in on that because it's so damaging. It is incredibly incriminating. Tickling thighs, tickling up underneath the shirt, cuddling with your niece under a blanket. This isn't a mistake. This isn't an accident. He knows exactly why he's there, and he's got to figure, well, I need to come up with a reason to be in that particular spot. And he comes up with this game. He comes up with cuddling in a boat. We're just cuddling, we're just staying warm. It's Bart. I was there. I was just getting groceries. I just happened to be there when it happened. Defendant wants to focus in on the fact that there were other people there and it was impossible for it to happen with other people there. The victim testified to absolute certainty when this began. She can't provide particulars. Defense counsel asked her in a deposition, were you 15 or 16? She says, 15 or 16, somewhere in there. Victim doesn't know statutory rape laws. Defense counsel never followed up and said, are you exactly sure you're 15 or 16? Is there any way you can determine when exactly it started? That question wasn't asked. When it was asked by me to the victim, she recalls softball. 8th grade summer following her 8th grade year, before she started her freshman year. That's the trigger. That's how she remembers these things. We talk about the weddings. We talk about major life events. When things happen, we don't remember the specifics. We remember general things. You don't forget, however, you do not forget, is the first time your uncle takes his hand, puts it under your pants, and touches you in your vagina. You don't forget that. And she testified to that. Defendant likes to paint a scenario where there's 20 people in a living room and everybody sits down for 5 hours and nobody gets up. Everybody sits down, everybody's in the same spot, nobody gets up. There's no other access at any point in time. That's just not the case. You heard testimony, and it's possible that they're on the couch together at the same time. Think in the years these families associated with each other, the systemic, family outings, ongoing, continuous family functions, that at some point in time the two of them weren't alone. And what a great built-in alibi. It couldn't have happened. She's lying. It couldn't happen. There's people all around. You remember the people all around. It couldn't have happened when we were in a boat, regardless of whether or not I had to get my sleep, because there were people around. The victim does not get to pick and choose when she became a victim. He did. And now he's trying to use that against her. Defendant wants to talk about being absolutely sure. Incredibility. That's for you guys to decide. Solely you guys. Victim testifies, she's absolutely sure. There's no doubt in her mind. You know who's not absolutely sure? Who's not absolutely sure is the man who watched himself say things during a police interview on this TV and less than an hour later deny having said them, or can't remember why. And that's all I have listed. Common sense. That's what the instructions ask. Use your life experiences, your common sense. It is not beyond any and all doubt. It's beyond a reasonable doubt. Not 100%. There's no metric for it. It's a fluid concept. The instructions are there. They clearly define what reasonable doubt is. Beyond reasonable doubt, not beyond reasonable doubt. I thank you guys for your attentiveness. I appreciate your patience with our pauses in between sessions. I'm going to ask that you go back I'm going to ask you to go back and you hold him accountable for not just destroying the victims' lives, but the families as well. Thank you.
Ladies and gentlemen, let's finish reading the jury instructions.